All right. Well, I think we're ready. So we'll get going. It's so nice to have all of you here, some new faces in person versus online, and it's great to have us all together. So thanks for coming out on this stormy night. So for those of you who are online, my name is Katie McKinney, and I'm the founder and the head of school for the Classical Academy de Lafayette. We are supported by Hillsdale College, a private college in Michigan. And we serve the St. Charles County grades K through 11 next year through 12th. So we'll graduate our first class next year. Many of you supported our virtual gala last year, and we're very grateful for that. And this year, in fact, on Saturday, we're going to put on our best Western wear, and we're going to enjoy the beautiful barn setting of the Femme Osage Grove, while enjoying delicious barbecue, American and folk music, silent and live auction items, including things like an elk hunting trip, New York Broadway shows, a meet and greet with Carrie Underwood, just to name a few, and then a fund to need, which will be a paddle raise to benefit our school. So some of you might be joining us for that. And if you are, great. If you haven't gotten tickets yet, we still have a very few left. And if you can't join us, but still would like to support our school, we'd be very grateful for your generous gift. And you can do so at our website, which is calschool.org. So we'd love to have you support, whether you're in person or virtually. So we're going to switch gears. We often talk about the Western tradition here at Cal. We say we teach the best of the Western tradition. But if you've never been taught what the best of the Western tradition is, then you might nod your head like I once did, but not really know what it means. Our history teacher here, Mr. Preston, actually gave a history series talk all on the Western tradition a year or two ago, and highlighting key components such as independent thinking, which is what the Western tradition is, rewarding the individual for the contribution they make and not taking 80% and giving it to the government, and the protection of individual rights. Things a lot of us probably take for granted, but that stem back 2,500 years. So we can think of this as any civilization that comes from the convergence of Greece and Rome and the Hebrew cultures, like a country like America. And it dates back as far as 2,500 years, the golden age of Greece. But these concepts are not old. They're not antiquated, as one of my colleagues from another private school once told me. Rather, these concepts are alive and well, and they highlight the best of the human pageant. The Western tradition needs to be taught and lived, which is what we do here at Cal every single day. So tonight, we're going to continue that education with Mr. Preston for our adults. So onward to this evening. In the past few years, Mr. Preston has invoked family and childhood experiences that he's shared with us. But tonight, this talk is a little different. It's a little more local and a little more recent. In the late 1990s, Mr. Preston was coming to the end of a multi-decade career in investing. After 10 years advising retail clients as a stockbroker and a decade of managing investment trusts for a local private school, he was informed that the school would be hiring a well-known money management company and that his position was going to be eliminated. So instead of taking severance pay, he asked that those resources be redirected to support him in earning his master's so he could teach his original love, history. He's grateful for Webster University for its plethora of night and weekend classes, which allowed him to double up his course load, and he received his degree in less than 18 months. But the real story is the part of the journey that led us to tonight's talk. While he enjoyed many of his courses during that master's program, it was two specific courses that he particularly enjoyed that were taught by a longtime Clayton High School teacher that lit a fire inside of Keith. It's hard to imagine that you would need your fire lit, but it was so. So these two classes were, one was on US Constitution and one was on the Bill of Rights, and it changed his view on US history. Keith's love of the greatest documents in US history and the responsibility of these 9 justices that were tasked with interpreting it is due to the enthusiastic and knowledgeable and this knowledgeable high school teacher. I have a feeling you're doing that for our kids too. I can't wait for them to say, I was one of the ones who got Mr. Preston. So let's dig into this history of the Supreme Court, a branch of our government that is very, very much often least understood. Discuss how we got to the place where the Supreme Court nominations have become sort of a political circus, and why this branch is so powerful. What does the future hold for the only branch of government with unelected members whose decisions cannot be countermandated without a constitutional amendment? So talking to us about why we should care about the Supreme Court is Mr. Preston. So please help me welcome him. Thank you.
Thank you.
Okay.
Thank you, Katie, and thank you all both here and those of you who are online. I see we have 14 people online right now, and hopefully we'll get some more as we go through it. So the Supreme Court, we hear a lot about whenever the nomination process comes around, and we'll talk a little bit about that at the end of this talk. But as with almost everything, every subject that I've dealt with on our history series, I like to go back to the beginnings of where something happened and what the sources and what the traditions have been in this country. And it kind of relates to some of the work that goes on here at Cal. As Katie said, we're very closely aligned with Hillsdale in many ways, and we use their Barney Charter School Initiative curriculum for our grades here at Cal. And the middle school, which is one of the grades that I teach here, just this past fall, got a lot of what you're going to hear about tonight, because in the Barney Charter School Initiative curriculum for the middle school, they get 6 weeks on the U.S. Constitution. You shouldn't even be allowed to be a citizen unless you don't know something about your Constitution. Obviously, we're not going to do that, but conceptually, it's something that's really important. And I believe from what I'm hearing that there's going to be more of a discussion this year in our presidential election coming in 2024 about the importance of a civic education for students in America and for Americans to understand the nature of the government, particularly because we were the first ones to say, no, the people themselves can choose their own government. So you ought to have a pretty good idea of what that means and the powers there and how that process goes. And I'm sure most of you here, I'm looking around here and I'm seeing a lot of people have hair the same color I do. And so we grew up with a civics education. I can tell you right now, also as a teacher who's been teaching for over 20 years now, that a lot of schools do not give them a civics education. They may call it civics, but they're not at all getting what we used to call how a bill becomes a law. What are the three branches of government? What do they do? What role do they play? And so it's something that really needs to change. So let's get started here. The U.S. Supreme Court, let's go back to the beginning of how this all goes on. And I'm hoping this will work, and it's not right now. So let me see if maybe this will make a difference. Yes. Okay. So the judiciary branch of the government we call it the third branch. And the reason we call it the third branch is we talk about them in order that they come in the Constitution. So Article 1, the Constitution, is about the Congress and its powers. It's very specific. And there's a reason for that, because of the time period that they spent putting together the Constitution, which is basically May through September 17th, which we now call Constitution Day. That's the day they adjourned. Most of that time period was spent figuring out the powers and how they're going to put together the legislative branch that makes up Article 1. About halfway through that, they knew they're going to need an executive. They kind of started working on Article 2, and a lot of that got set off to the side, but eventually got put in there. The one they spent the least amount of time talking about of the three branches is the judiciary. In fact, Article 3 is the shortest of the three by plenty. And really only the first part of Article 3 talks about the judiciary. The rest of it talks about, how do we define treason and some other things that you're thinking, why is that in the judiciary? Because they would think a trial would happen in something like case. So it made sense to go in Article 3. But Article 3 basically says there will be one Supreme Court of the United States, the federal government that they're creating with this new government that they've put together here in Philadelphia the summer of 1787. And the reason that probably didn't go any deeper than that is they said, what about other courts? Obviously, when they had other courts. And so they just kind of tossed it out there and said, and any other courts that Congress sees fit to create. That's Article 3, Supreme Court and any other courts that Congress seeks to create. And Congress has done that we have a 3-layer system in the United States. At the basic level, federal courts, you have the district court. We have one down here in St. Louis. Those of you who've been there, it's that green dome building there where actually the Sanford case, the case that decided whether or not a man had a right to be free, came in that courthouse down there. Then you have an appeals level, which can go to from several different courts to different appeals courts. So there's a number of appeals courts that handle appeals from different district courts. And then after that, you have the Supreme Court. Now they've created other side courts. There's tax courts. Hopefully none of you have been to one of those. Espionage courts, which are very special because you need to have an open system, and yet at the same time you need to protect confidential information and top secret stuff. So you have an espionage court, but basically our system is a 3-level system that Congress created at the Supreme Court. And then they thought most things would happen in state courts, which is why they didn't worry too much about it. And over time, we've evolved that process where things that normally would have been in state courts are suddenly more and more showing up in federal courts. And we can talk about that certainly in our question situation after that. So the third branch of government was almost an afterthought as they're trying to all get the job done, finish up with the writing of it, and go home. Nobody wanted to stay in Philadelphia any longer than they had to. They wanted to go back to their home states. And they really didn't know what to do with the judiciary. You thought that this would cover all the laws that need to be interpreted, because after all, the Supreme Court's one and only job was expected to be interpreting the new Constitution. If it got ratified and got approved by the states, then that would now be the overall rule book, but almost everything of any consequence would happen at the state level. That is not the way things have evolved here. So Congress is the one that ends up creating this court system. Now, the first Chief Justice of the United States Supreme Court was John Jay. Anybody that's taken their history, and I know we have a couple of history majors out there, John Jay was the man who came up with the first U.S. treaty between the United States, the new nation, and its former mother country, Great Britain. John Jay was also involved in writing some of the Federalist Papers. It was a good choice, but there wasn't much for John Jay to do, because while they knew they needed a Supreme Court in case they needed to interpret this new Constitution, in the meantime, just about everything that they worried about or needed to address would be something that would be addressed in a state court. So there wasn't a lot for the Supreme Court to do in the early years of the United States government. Multi-state agreements, which is one of the reasons we ended up having a new government, would be something that were permitted. There was an actual clause in the Constitution that talked about the federal government will regulate the commerce between the states and with other countries. And so that's fine. And for the most part, that's stated pretty plainly, and no one really needed an interpretation of what that meant. So it wasn't really clear on what a Supreme Court would do. We didn't have a lot of federal laws in the early time. And we were just in the process, after the Constitution got ratified, of adding the first 10 amendments to the Constitution, which were basically over rights issues, as opposed to hard and fast rules of how states would deal with each other, federal laws, how they would take precedence. We knew that the precedence was federal law, the Constitution, federal law, state constitutions, state law, and so forth. That would be the ranking of what would have precedence in any case. Everything changed with John Marshall. And I love telling the story to my students because John Marshall's a great story. He's a great story for a couple of reasons. If you know the story, some of you will go, I already know that story, but I always think it's fun to throw a little human interest in there. So John Marshall is one of what we call the midnight judges. When John Adams lost the election in 1800 to Thomas Jefferson, he went and said, oh my gosh, the Federalist Party is going to lose power. So the idea was, we're going to put as many Federalist judges in, since they're going to be there for life. We'll nominate them. We'll have this old Federalist controlled Congress approve all these judges before the new Congress is seated, the new president comes in, and of course Thomas Jefferson is going to want his own people in these spots. So we're going to fill the spots as much as we can. And they're referred to by historians as the midnight judges, because it's at the midnight of John Adams' presidency. And Chief Justice John Marshall is one of them. And at the time, I don't think people knew what a big deal that would become. Once he became Chief Justice, it did become a big deal. The other part of the story that's kind of fun is Chief Justice John Marshall and Thomas Jefferson, third president of the United States, are in opposite political parties, very different ideologies. And that's not the last of it. They're also cousins. Okay, so family didn't go so well. And the other thing that's important that you begin to realize the significance of this. So even though you didn't have a constitutional limitation on presidents at that time, it was kind of assumed everyone would serve no more than 2 terms. Why? That's how many terms George Washington served. So if it was enough for George Washington, it's enough for any other president until Franklin Delano Roosevelt come on. That's another story for another time. But anyway, so you've got Thomas Jefferson who's going to be president from 1801 to 1809. Chief Justice John Marshall, right before Jefferson becomes president, is made Chief Justice. And how long will the Chief Justice be there? Well, Chief Justices, any justice is there for life, or unless they retire, which some have done from time to time, 35 years. Long after Thomas Jefferson was gone, his political rival, the Federalist, Chief Justice John Marshall, is on the Supreme Court. Now, at the time, you would think, okay, maybe that's inconvenient, but maybe not such a big deal. But it is going to be a big deal. And the reason it's going to be a big deal is because of a ruling that John Marshall makes early on during his time as Chief Justice. So during that period of time, one of the things that wasn't real clear, at least it wasn't written down clear in the Constitution, is, okay, who decides what is constitutional and unconstitutional? And of course, as you usually see in any kind of situation, like you'd see in the committee or, the Congress said, we decide what's constitutional and unconstitutional. The president says, we decide. And John Marshall says, you're both wrong. We, the Supreme Court, decide, because we are the ultimate court of the land. Thus, we judge what is the ultimate law of the land, the Constitution. Now, the thing that happened in this case is, it often happens in these kind of cases, it came in a case that didn't seem like it was a big deal. It's called Marbury versus Madison. And the idea was there had been a judge, one of these midnight judges, had made his commission to be a judge, but it hadn't been finished off by the Congress. He says, well, it shouldn't make any difference. I should still have my judgeship. Okay. And it was ruled that according to the Judiciary Act that had been enacted a couple of years beforehand, that's the way the process was supposed to go. Once someone is given their commission, then they're supposed to be a judge. So John Marshall gets his case and he sees an opportunity here. He says, unfortunately, Mr. Marbury, that's not the way it's going to work. You do not get your commission, Marbury. Oh, and here's why. Because the Judiciary Act was unconstitutional. And he said the Supreme Court is the one that gets to decide if an act is constitutional or not. So we've decided this act is unconstitutional because we have the power, what's known as judicial review. Any action, act, law, whatever, that the Supreme Court decides is unconstitutional, they have the right to strike it out. Okay. And that's going to come into play in many of the cases we're going to be talking about tonight, including some of the ones that we're talking about happening in just the last few years. The power of judicial review, the power of the Supreme Court to decide what is and is not constitutional, is not in the Constitution written. It's interpreted in the Constitution by John Marshall, who is as a Federalist. The Federalists always interpret on the side of the federal government and an interpretation of its powers. And we call that broad construction. When interpreting law, you have broad construction. And all my kids in my middle school class, we talked about this year. Jefferson was a strict constructionist. And as such, he said, if I don't see it written in the Constitution, federal government doesn't have that power. And then the Louisiana Purchase happened, and poor old Jefferson couldn't find anything in there saying that the federal government had the power to buy land. And so for that one act, Thomas Jefferson was a broad constructionist. And then that's how we got the Louisiana Purchase. Now, to kind of finish things off, he also kind of interpreted it as a treaty, even though it wasn't a treaty. And so that was kind of the way that got done. We'll talk about that kind of interpretation a little later when we talk about Obamacare. Same kind of deal going on there. Anyway, so you get to decide as the Supreme Court what is and is not constitutional. And because he's there for 35 years, John Marshall's stamp on the Supreme Court is really the one which is most of the precedents that we see today. All are things that came down from interpretations of the Constitution that John Marshall, as head of his judicial review view of the Supreme Court and its power under the Constitution, did. So as a Federalist, again, he's going to serve until 1836, 20 years. No, that's not right. Sorry, 10 years after 20 years after the party ceased to exist, 10 years after Thomas Jefferson ceased to exist. So this is why federal appointments can be so important. Because they can last for a long time. They can last for life. I know right now that, and I'm not going to get into a two-side issue of this, there are people who are trying to find a way to impeach Clarence Thomas. Clarence Thomas has been on the court for 30 years because he was put there when he was in his 40s. And so it has a long-lasting impact when someone gets put onto the federal court, any federal judiciary position, because it's a lifetime appointment. So 35 years of the Marshall Court and the rulings that came from his lifetime in that appointment. And some of them are ones that we still argue about today. But they have held up as precedents, because one of the things that happens in something like a judicial decision is made is that once you have that, that is now the precedent. And while you can reverse precedent, as we saw recently happen with the Dobbs decision, which reversed the precedent of Roe versus Wade, and yes, we'll be talking about both those tonight, it's not very often that you see that happen. And it's not always a good thing or a bad thing. But we'll talk about it as we get to it. All right. So after Marshall is gone, Andrew Jackson is president of the United States, and he's going to appoint someone who has his view of things. And Andrew Jackson is in many ways a Federalist in the way that he used the executive power when he was there, but also as a Southerner of sort and as a slaveholder. He also saw the persuasion in his mind of states' rights. So he picks a guy to be the Chief Justice of the Supreme Court named Roger Taney. It doesn't look like it's pronounced that way, but it is. He's the one who his most infamous decision, and probably one of the most infamous decision in the life of the Supreme Court, is the Dred Scott position. The decision that said that even though Dred Scott, who was a slave, had been taken by his master many times to states where slavery is banned, and thus he felt he should have gotten his freedom, Roger Taney's decision about Dred Scott had more to do than just about whether or not Dred Scott had the right to be freed. Taney's decision also covered other things that he used the power of the Supreme Court and its interpretation of judicial review to talk about other laws having to do with slavery. He said, first of all, the Constitution was written by white men only for white men, and anyone who tried to make restrictions on slavery, which is provided for in the Constitution, those are unconstitutional. So he said, since slavery is in the Constitution, restrictions on slavery are unconstitutional. And that meant that the Northwest Ordinance was unconstitutional, the Kansas-Nebraska Act, the Missouri Compromise, all those things were unconstitutional. Now, we can be grateful to Mr. Taney about one thing, that is this decision, which most of the northern part and much of the western part of the country thought was wrong, his decision is responsible for getting Abraham Lincoln back into politics. So from that stretch of things, it's something we should be grateful for. But the fact of the matter is, it really is a problem going forward in a country that's wrestling over slavery, the interpretation that restrictions on slavery were unconstitutional. Now, this is not the last time that Mr. Taney is going to anger a large part of the country with his rulings. Mr. Taney was also Chief Justice when the Civil War began. And as such, President Lincoln, who had just recently become president of the United States, finds himself in a situation where more and more states are leaving the Union, especially after the firing on Fort Sumter. And if you know your geography, poor Washington, D.C. is smack dab in the middle of Maryland. And Maryland's legislature was about to meet and secede from the United States. which means that Washington, D.C. would have been settled right in the middle of enemy territory. And so Lincoln says the Constitution is not a suicide pact. I am willing to do whatever it takes to keep Maryland in by the Union by force if necessary, including jailing the Maryland legislature, which he did so that they could not vote to secede. And Roger Taney said was going to write them all a writ from his position of Chief Justice, letting them out of jail. And Lincoln said, I might have to jail the Chief Justice of the United States Supreme Court. Now, fortunately, it didn't go to that, but he did consider that at the time. And that would have been an interesting one for us to discuss as far as constitutionality. In the end, he simply ignored the order that Taney had written and said, no, they're staying right there. Now, to be fair, this is one of the complaints I hear all the time. I'm a big Lincoln fan. I'll be right up front about that. And I know there are a lot of, shall we say, rewriting of history books that have said a lot of things about Lincoln, some of which, okay, might be true, but how many other presidents have had to fight a civil war? None. And so Lincoln, in many cases, is faced with a situation where he says, I might have to reinterpret the way the Constitution reads. Now, one of the things that's always thrown at Lincoln all the time is that Lincoln suspended the right of habeas corpus, which means you have a right, if you're arrested, that they have a certain amount, a small amount of time to tell you what you're accused of, or they have to release you. And he suspended that right in certain areas where it was the rebellion was going on. Certainly the border states who were talking about voting secession. Now there is a provision in the Constitution for the suspension of habeas corpus in times of rebellion or war. And that's what Lincoln used it for. However, that right is given to the Congress. So you can't have a president who's a dictator and says, well, I'm going to suspend it under habeas corpus. What most people don't realize when they talk about that, in those days, Congress met for about 6 months. So oftentimes they would show up in October or November, they would meet, they do the business they wanted to do, and then they all went home before April because that's planting time. And just about all of them were one way or another involved in agriculture. And so they met for 6 months out of the year. Well, when the Civil War starts and Sumter gets fired on, Congress is not in session yet. And so there is no Congress there to suspend habeas corpus. Now, when they came back, they all post-approved what Lincoln had done. But the fact of the matter, this is again where we get into these situations. How do you interpret that? Did the president act unconstitutionally? By the letter, perhaps so. But again, you're fighting a rebellion, you're fighting a civil war, you're fighting something which is, an extreme circumstance, and Congress isn't there and you have to act. And as I said, there's a dispute about whether Lincoln actually said it, but the part that people have used a couple of times and actually comes much later, I think Oliver Wendell Holmes Jr., somebody uses, says the Constitution is not a suicide pact. You have to have a way to defend the country if need be. At times of war, make things extreme. All right, we're going to jump ahead past the Civil War now to Plessy versus Ferguson. Plessy versus Ferguson is the one that most people who know about it, they may not know the name of that particular case, but it's about the challenge was made about whether or not segregation was unconstitutional. And the man who took the case here was Mr. Plessy, who you see here. He's 1/8 black and 7/8 white. And the way things were judged that day, he would be considered black because there was 1/8 black in him. And so under Louisiana state law, he's riding on a train and he's classified as an African-American. And they say, you need to sit in the colored section of the car. And he says, I'm not going to. That's unconstitutional. He gets arrested. The case goes forward. It goes to the Supreme Court. Now, this to some extent was a setup by a group that was in Louisiana to decide we're going to challenge segregation law down here. We're going to use this case. And Plessy agreed that he'd be the test case for it. And particularly because of the 14th Amendment, they felt they had a strong case. 14th Amendment was one of what we call the Civil War amendments. There are 3 amendments that passed after the Civil War. The 13th Amendment is obvious. It eliminates slavery. That gets ratified in December of 1865. The kids go, wait a minute, I thought the Emancipation Proclamation. That's why I get to have fun and tell them the story about what the Emancipation Proclamation really did, because Lincoln knew as a lawyer that he did not have the power to free the slaves. What he did have the power to do as commander-in-chief fighting a rebellion against the authority of the federal government is to confiscate the property of people who are in rebellion against the United States government. So the Emancipation Proclamation only freed slaves by confiscating that property, because they're the ones that were saying it was property, that these people, these slaves, were property. Confiscate their property and then let them go. And that's where at the end it says, they shall be forever free. Once they've confiscated them, now they can be freed. So that's how we're going to remove the support of the war effort in the South. It's by confiscating their property. Now, the Emancipation Proclamation did not free anybody in the border states, which stayed in the Union. That would be Missouri, Kentucky, Delaware, and Maryland. It also didn't free any of the slaves in area where the Union had already reoccupied territory. So, for instance, in early 1862, the Union fleet makes New Orleans surrender. For the rest of the war, New Orleans is under federal occupation. None of the slaves in New Orleans were freed under the Emancipation Proclamation. That's why you had to have a 13th Amendment, which would forever eliminate them. So that's what happens in the 13th Amendment. The 14th is the one that when the freedmen were not being treated fairly as equal citizens, they said, all right, 14th Amendment, everyone has the right to equal treatment under the law. Everyone has the right to the same treatment as any other citizen in any state and in the United States. It's the only one that mentions a state in it as well. And so he said, under the 14th Amendment, I have not been given equal treatment because I have 1/8 supposedly African-American blood in me. I can't sit in the same part of the car as everyone else that's in there that's a citizen of Louisiana in the United States. Now, why did that fail before the Supreme Court? The Supreme Court knocked it down 9-0. And the biggest reason is because at that time, the court knew that they would be faced with challenges all over the place. They said, no, this is for the states to decide, strict construction, okay? The states have to decide this. This is not for the federal government to decide. And so that did not happen. However, what it did set up is that all other challenges to civil rights afflictions in the United States history, certainly going on from 1940s on, we're going to be basically on 14th Amendment rights. So the 14th Amendment is the reason that you got segregation ended. The 14th Amendment is how you got same-sex marriage in this country. A lot of the things over the last 70, 80 years have all come from the 14th Amendment, which of course was written to make sure that the freedmen, as they were called, had equal rights. That did not happen because it was not enforced. And the decision was made that we're not going to fight a second civil war trying to enforce the 14th Amendment down south, and that's when all those Jim Crow laws come in. We'll talk about that later on too. So separate but equal was considered acceptable. And the colored car was supposed to be the same as the non-colored car. And because they're both somewhat equal as rail cars, then that was acceptable as far as the Supreme Court was concerned. And the idea was that schools would be that way, that everything would be separate but equal, water, fountains, bathrooms. And of course, reality was that was not the way it was. But that's what Plessy versus Ferguson said. Separate but equal is uncertain. And that kept them from having to try to force the South to do what they needed to do. So that decision is 1896, before the turn of the century. Gwynn versus the United States, 1915. This is where the grandfather clause was knocked down. And it's, again, the 15th Amendment also passed just a couple of years after the 14th Amendment, said that everyone has an equal opportunity to vote. And so when Reconstruction ends and the old Confederates are back in control of all the powers of levers of power down in the South again, laws started being passed to try to keep the freedmen from voting. And so you came up with things like poll taxes. You came up with things like the grandfather clause, which I'll explain in a second. You came up with literacy tests because most of them were uneducated and they could not read or write, as a way to prevent them from being able to vote. So the first one they could go after was the grandfather clause. And when I say they, by this point in time, you'd had the Niagara movement, as it was called, because they met near Niagara Falls, right around the turn of the century. And the formation that came out of that was the NAACP, which I have to explain to my students because I've never heard that term before, because they don't know what colored people means. So NAACP means National Association for the Advancement of the Colored People. And they look at me like this. I said, that was the kindness phrase that was used at that time when they were put together. So they took the lawyers that they had at the time. One of the heroes of this is W.B. Du Bois, which some of you may have heard of, who was one of the early founders of the NAACP. And they went before the Supreme Court eventually and proved that the 15th Amendment was being violated by the grandfather clause. Now, what did the grandfather clause say? If other people, freedmen and their descendants, could not vote before the 15th Amendment had been ratified, then their descendants did not have the right to vote anyway. So it was basically, by the time it was being forced, if your grandfather didn't have the right to vote, then you didn't have the right to vote. So that was what the grandfather clause was. And in 1915, the Supreme Court said that the grandfather clause violated the 15th Amendment, and it certainly violated what it was intended to do. Many localities continued to ignore the Supreme Court findings. And we eventually had to have, I think it's the 24th Amendment that had been passed just to eliminate poll taxes alone, to get rid of the poll taxes, to get rid of the literacy tests, and then the Civil Rights Act of 1965. I mean, the Voting Rights Act of 1965 is where you really had federal government enforcement of the decision made all the way back in 1915 by the Supreme Court that the grandfather clause was illegal. Okay. Now, the one that probably most people are aware of and is kind of considered the beginnings of where we look at the modern civil rights movement is Brown versus the Board of Education, which is a reversal of Plessy versus Ferguson. And for some time, the NAACP had been looking for the perfect test case to put before the Supreme Court so that there was no other way to get around it other than ruling that segregation in education was unconstitutional. So rather than picking a place in the Deep South, they picked Topeka, Kansas, where there was segregated schools. And they took that test case there, and there's a little girl who is the Brown of Brown versus the Board of Education. Board of Education, the Board of Education of Topeka, Kansas, sued him saying that this was unconstitutional. And Earl Warren, in his first big ruling of his court, says either we're going to get rid of this 9-0 or not at all, because there shouldn't be any question. It should be unanimous if we're going to do this. And it was unanimous, 9-0. So it's a big first markdown for the Warren Court. By the way, and a little side thing here, in all the years that I go through things, I love looking for some sort of story to kind of have fun with. And two things that I did not know until recently. Number one, Earl Warren had been governor of California back when there were Republican governors in California. And Earl Warren had been Thomas Dewey's running mate in 1948 when Thomas Dewey lost that surprise election to Truman in 1948. So he was the vice presidential candidate, and then was going to go back and just be a Republican in California. And that's when Eisenhower picked him and said, I'll make him my chief justice. And he did not have a law background. But you don't have to be chosen to be chief justice. It helps, and you would think that you would. But the fact of the matter is, Eisenhower got more than he bargained for, and that's okay. That happens sometimes too. That's part of what happens in history. Anyway, this is a first big ruling for the Warren Court, and the actual decision itself announced that separate is inherently unequal. Now, does that mean everything changed all of a sudden? Not at all. Most of us that are sitting here know that's because some of us lived through at least part of this time, certainly when the civil rights movement was going on. It was going to take many years and many rulings on the Supreme Court and many cases in some of these different localities and states to eventually try to undo these. I saw recently that one of the surviving Little Rock Nine, if you may remember that group of 9 students that decided that they wanted to apply to be in Little Rock High School, which was an all-white high school at the time. And in the end, in order to do that, each one of them had to have a 101st Airborne Trooper accompany them to classes and the restroom and all that sort of stuff to protect them because of how violent the reaction had been in Little Rock. And it was Eisenhower in the end that had to make that decision that he was going to have to protect the students and protect the people who wanted to go into to integrate the school, basically. And to some extent, Eisenhower was opposed to it because he knew it was going to be trouble. And he'd spent enough time in the South to know that Southerners saw this differently. And when I say that, a lot of people say, well, because they're all racist. I said, no, you don't understand. If you don't understand the South, to send troops down to enforce something like that to the Southerners reminded them of Reconstruction. When I teach Reconstruction to my students, I say, how many of you, especially the high school kids who had US history in middle school, how many of you know what Reconstruction is? The kids from the North, almost none of them know what Reconstruction is. The kids from the South had 2 to 3 weeks on Reconstruction alone. Because for a number of years after the Civil War, there was a full-on United States government military occupation of the South. You did not have states in the South. They had not been reintegrated back in the Union. So for those people who had grown up listening to the grandparents talk about when the Yankee occupation had gone on in Texas and Louisiana and Mississippi and stuff, to them having federal troops come down and enforce this decision by the Supreme Court, to them reminded them of stories they'd heard from their grandparents about Reconstruction. And that's not a justification, it's an explanation. Now, you can't understand sometimes how people react to things until you know what their background is and what their experiences are. So when I teach my kids, I want to make sure that they understand. You don't have to agree with it. I don't agree with it, but you have to understand it. Because things like that get passed down from generation to generation. I think to a great extent, a lot of that is gone now, but for a long period of time, I was married in the Southern family for a number of years, and they saw things very differently. I did, not on those kind of things, and not really on race, just on the states versus the government and ancestral background and all sorts of things. We all see things through different lenses, and so the challenge at this time was the way that the South saw that. Eventually, they got that. Probably didn't hurt that they began to realize that they would start getting more students if then they open their doors to everybody, and that's eventually, obviously, what happened. So it's the beginning of attempts to eliminate segregated schools and the opening salvo in the war against Jim Crow laws in the South. But it took a number of years before a ruling, and this is what often happens, becomes enforced, depending on how deeply embedded it is in the society that it's in. Okay, Engel versus Vitale, and this is one that I know that we've had a constant a discussion about once in a while. This is the famous one that people cite a lot of times as this is when prayer left schools. So I want to give a little explanation on that, what exactly was in the decision, and have people interpreted correctly what this decision made. So there was a law in New York at the time allowing prayer in schools, in fact, encouraging prayer in schools. How many of you were in a school when you were a little kid that they did a prayer in the beginning of schools? Okay, there's a few hands that go up. So some of us remember what happened at that time. And then you had this ruling which happened in 1962. And again, that does not mean that immediately everyone stopped doing prayer in schools. There was a long period of time we were going, well, what does it mean? Can we do it this way? You still have athletic teams who were having a prayer before they went into an athletic contest. So this was a challenge to a New York law that allowed prayer in schools. The challenge was led by a number of atheists who said that this is a violation of the Establishment Clause of the First Amendment. So that you understand what that means, there's two parts in the First Amendment that have to do with religion. The first one is obviously everyone has free exercise of religion. The other one is the government shall not permit any establishment of religion. Now, the people who wrote that at the time were saying, we don't want a state religion like we had under the British, where the religion was the Anglican Church. The king was the head of it. So if you're loyal to the king, you had to be, you had a state religion there. And they didn't want that. In fact, almost even before independence was declared, one of the reasons that Thomas Jefferson was asked to write the Declaration of Independence, because he had written quite a treatise on freedom of religion in Virginia, and had got some statutes passed there that allowed that. You had several states which had been set up in order to allow people from all kinds of religion come there. You had a large Jewish community in Rhode Island. Maryland was set up by Catholics who felt they were being picked on by the Anglicans back in England. So, we had a long tradition of that. So the Establishment Clause was to prevent a state religion, not to say that there shouldn't be religion in American society. And that's the thing that we've had the problem with, is determining exactly what is meant by establishment of religion. Now, at the time the court decided, it was a 6-1 There was one lone dissenter in there. There were two people excused themselves. I wasn't able to find out exactly why when I went back to do my research on that, but I think they both felt that the people who were arguing the case were a situation where, and that case has kind of come before us and I should recuse myself. And so they did. So you ended up having a 6-1 dissent. Now it's interesting what the lone dissenter had to say. It was Potter Stewart. He said, how is it an official religion to let those who want to pray, the opportunity of sharing in the spiritual heritage of our nation? Okay, because you'll find a lot of talk about the founders and the framers who wrote the Constitution talk about divine providence. That was an easy, non-ecumenical way in those days to say God, divine providence. So we're going to see a test case on maybe reinterpreting some of this in a case that's before the court right now. See, that's the thing. These things are still going on. Over the last number of years, as some of you know, some of the U.S. mail services are starting to deliver on Sundays. And there's one worker in particular said, no, I can't. Sundays when I go to church and I'm a part of a deacon of my church, whatever it happens to be, he's very involved in. And he's been told that he might get let go if he doesn't, agree to work on that day. And so he has challenged that. It's a violation of the free exercise clause in the First Amendment, as opposed to Establishment Clause. And the court is taking up that one. And I don't know, we never know exactly when they're going to announce something, but that will be very interesting to see what the current makeup of the court, where they come down on that particular case. So it's still something being discussed. All right. Now, this is where things are going to get controversial. In 1965, there was a decision that was made called Griswold versus Connecticut. And on the face of it, it seems pretty innocuous. Planned Parenthood in particular, but other people who were involved in the birth control community at that time had challenged the court in Connecticut, which was an 1870s law, which said that birth control was illegal. Now, to understand, I remember I talked about this back in the time when I was telling the kids that they go, illegal, how could it be illegal? I said, well, you had a lot of strong beliefs, some were linked to certain religious beliefs that you had been told by God to go forth and multiply, and anything that stopped that would be illegal. And if you had a legislature, you could pass a law like that because they think it would be good for the state to have more children and bigger families, and no one was going to challenge it in those days. Well, now, you do get to a point in time saying, wait a minute, that says that I don't have the freedom to decide when to have my family or if to have a family. And so they challenged that Connecticut law. Now, you would think that what you would do is, why don't we just get the Connecticut legislature go, this is a silly law from 1870, let's change it. But they did see an opportunity to do something else, and that is to challenge whether or not there is a right to privacy in the Constitution of the United States. And the interpretation was based on interpretation of what we call the Ninth Amendment, which many people call, this is James Madison's catch-all. There was a worry when they were putting together the Bill of Rights that people would say, okay, these are all the rights that you have in the Bill of Rights, but your right is not mentioned in here, so you don't have it. So he wanted to make sure that that would not be an excuse by future decisions, governments, authorities, whatever. So the Ninth Amendment says the enumeration in this Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So maybe you do have a right to privacy. It's just not specifically mentioned in the Constitution of the United States. And this whole idea of enumerated rights and unenumerated rights and implied rights and that sort of thing first happens on a big scale in Griswold versus Connecticut in 1965. And I think, as you can imagine, it easily, the Supreme Court said, well, of course, you have the right to privacy, whether we agree that it's in the Constitution or not, you have that. However, 10 years later, the Griswold ruling led to probably one of the most famous modern rulings in American history, and that is Roe versus Wade. In fact, we were just talking about Roe versus Wade with my kids the other day. 1973, Jane Roe, whose real name was Norma McCorvey, had wanted to have an abortion, and she was living in Dallas, Texas, which outlawed abortion. And so, and working together with Planned Parenthood, she filed suit against the Attorney General of the area, Henry Wade of Dallas County, I'm sorry, not attorney, Dallas County attorney for the city of Dallas, Henry Wade. And so that's how it becomes Roe versus Wade, Jane Roe, which is another way to say John Doe, except with a female. And so that went to the court. Now, the state was told in the decision that in order to prevent someone from having the private right to decide whether or not to have a birth, that they had to show a compelling state interest in limiting that rights, which they felt that the defense, in this case, Wade and the Dallas people, had not shown. And so the decision was made in favor of Roe. In the decision, they mentioned the fact that that should be good to the end of the first trimester, or whatever is the viability of the child to live outside of the womb. So those were in the decision at the time. Today, of course, we've had a number of cases over that time going in different ways to regulate that decision. You have some states have decided that that decision can be made right up to, and it may be even some cases post-birth. The 2022 Dobbs case basically said Roe was decided wrong, that this should not be the perfect. Okay, and this is the part that you really have to understand the way the Supreme Court works, or is many people would say intended to work, which is deciding whether or not, first decision is this a case we should take? Supreme Court gets hundreds of cases a year. It's called filing for a writ of certiorari. Please hear our case, is what it says. And most of the time they say, no, it may be, no, we're not going to decide that. No, we've already decided that. No, that's not a compelling interest. No, that's a state law, not a federal law. And then there's some that they look at and they take and they vote on whether to take them because they think there's a compelling interest in clarifying something or establishing something that's new. Like, believe me, what's going to happen with technology over the next number of years, you're going to have a lot of cases going before the Supreme Court asking those kinds of questions. The 2022 Dobbs case, which has been so controversial, is a case that basically said Roe was unconstitutionally decided. The federal government should not be involved in this. In fact, before Roe versus Wade, the federal government was not involved in it. And probably, again, many of us here remember a time when you knew there were certain states where they allowed abortion and certain states when they didn't. And so what the Dobbs case in the end decided is that they were reversing Roe because they felt, not that they said, we're reversing Roe because abortion is wrong. No, we're reversing Roe because the federal government should not be involved in it. That should be for the state governments to decide, and the people through their elected legislatures and governors, as opposed to 9 people in black robes making that decision. And it would not surprise me over the next number of years to see more of those things done. So it's important. I really feel you used to be able to, you at least get the idea of what the debate was in cases in the media, and 20, 30, 40 years ago. I no longer see that. And that's unfortunate. It doesn't serve the country well. And as I always say, there's a First Amendment protection of freedom of the press, because we need the press to hold the elected officials accountable, not because we expect the press to put their thumb on the scales and decide who's got the good argument and who's got the bad argument. And we're going to set up our press reporting on that basis. And that's what's going on today. All right. That's my standing on my, did I give myself away there? I think I did. Anyway, so the Dobbs decision, and by the way, Sam Alito's grown a beard, and I think he should go back to who it was before. But anyway, there he is, who wrote the Dobbs decision, has defended it a number of times. Many people said, well, this was kind of inevitable when you got 3 people who, they say conservatives, I would say 3 people who looked at the Constitution and says this is either an issue the federal government deals with or doesn't deal with, or has been decided or was decided wrong or something like that, as opposed to here's what I want to accomplish with this ruling on the Supreme Court. So the question was, how would this be manifested in a decision, a reversal of Roe versus Wade? And rather than saying abortion is unconstitutional or something like that, they said this should go back to the states. Each state should decide. California wants to say there's no restrictions. That's California's right to decide that. Florida wants to say 8 weeks when there's a heartbeat is long enough to make your decision about whether to carry a child to term. That's Florida's decision. But it's not portrayed that way. And the unprecedented leaking of the Alito written decision to the press, which had never happened before in the 230 odd years of the Supreme Court, that a decision had been pre-leaked to the press, is all you need to know where the press is on that. The final version of the Dobbs decision was pretty much what the leaked decision was. A few changes were made. That's typically the process. They have a vote right after it's argued. And there's another thing that's important for people to know. So a case will be argued. Very shortly after that, the court gets together. They have they have a discussion, they debate back and forth. Most of the time they know what they're going to decide. They vote. After the vote is held, then the chief usually allows people to say, someone says, I want to write the decision, and you can, the majority opinion. There are a lot of times, especially important ones, other people say, well, I'm going to write one too. So if you write one that you think the majority is wrong, it's called a dissenting opinion. There's a major dissent that's written by somebody. You may have more than one dissenting opinion. People that agree with it, but maybe for different reasons, will write a concurring opinion with the majority opinion. And so that's what you usually see in there. And oftentimes a draft of it will go around amongst the court members, and they'll say, here's what I've written. And he'll even go to people they know oppose this decision, say, show me where I'm wrong, put some case thing in there, comment upon it. We look at it and we think they're all fighting each other because of the decisions. They actually get along pretty well, but they have different ways that they see things. You would hope so with somebody that's had many, many years in the court and had time to think about the Constitution. And we've all seen it in our own families. We don't always agree on things, but that doesn't mean you can't still be colleagues and affect the writing of the opinion, which oftentimes can have a big impact on how it goes down after that. So anyway, in this case, there were some changes made there. The final version was pretty much intact. What the court said in the end is something I always talk to the students about. Our system is a federalist system. When people say, what's going on in the country today? I say, what's the name of the country? It's the United States of America. Yes, I know it doesn't feel very united, but we've gone through this a lot in our past, but they're states. And the way the country was set up, we told 13 independent republics who had fought hard to win a revolution against a very powerful mother country who said, we're now independent republics. And they realized this doesn't work nearly as well as if we were all one nation, but there's certain aspects of being a state we want to keep. So if you can give me a government that allows us to keep the parts that we want to keep and be part of our nation as a whole, then we're willing to ratify that Constitution. And that's what they did. And then after that, you got another, 37 states that have all joined on saying, yeah, we like the original Constitution. We want to be part of it too. We have to remember it's a federal republic. And you have a national government, and the national government is given very specific powers to doing something, but a lot of it stays with the states. Now, how did that change? That changed beginning with the New Deal, when you got into a crisis situation where the federal government wasn't strong enough to handle a really tough crisis and say, okay, we're going to let the federal government do certain things we don't usually want it to do because it's a crisis. And then right as that was starting to get a little bit better, along came World War II. Okay, we're fighting two big wars, one in each ocean. We need a strong federal government. But over time, we've given each generation the idea that states are really kind of irrelevant, and what goes on at the federal government level is more important. It's not true. And a good proof of that is where have been the fights lately? School boards, okay? The idea of what goes on in education, what's going on in society, what's going on at the local level. Yes, the presidential election is important. Yes, congressmen and senators are important. But what's going on in our local school boards? What's going on in we're in St. Charles. We're having a big fight about what happened to the water system down there. Okay, and so those things are important. And when the Constitution was ratified, they never would have imagined, I believe, that we would have had the kind of strife about what's going on in Washington, D.C. Anyway, since the majority in the court decided, since there was no provision in the United States Constitution for decisions about something like abortion, that it's up to the states to regulate that. The closer we can get it to the people, the better it will be accepted by the people. And then people will say, well, what about Jim Crow? So, well, that was an easy one. They were not getting equal protection on the law like the 14th Amendment says. Well, okay, then what about abortion? Then shouldn't that be equal protection on the law? Shouldn't a woman have the right to? Yes, the difference in this case is there is, and we're debating about what that means, a child involved. That does make it a more difficult and a more murky thing to deal with. And so we're working that out as a society. It's just something we're going to have to come to grips with at some point in time, because now we're getting technology at the point in time now where, you know, the idea of when a child can be viable outside the womb is going to get closer and closer. And you also have, on the other hand, a demographic problem that's going on right now. Some of you may have been reading about this lately. Elon Musk tweeted about this other day and caught a lot of heck, but he doesn't seem to care when he catches heck. And that is that we've got a demographic crisis where there aren't enough children being born. And when you get a situation like they had in New York City in the last couple of years, where more African-American babies were aborted than born in the city of New York, you wonder if the people realize that, and what they really want to have happen, and they're going to have to make some decision about it. And I think the main thing is for people to be informed about that, and that's where we count on our press being fair and reporting the different decisions that are made. All right, Obergefell versus Hodges, 2015. The 5-4 ruling that required states to legalize same-sex marriage across the nation. You already had several states that had already passed same-sex marriage. I think it was between 6 and 8 at the time of the decision in 2015. And it was, once again, the majority opinion in that 5-4 ruling was written by Anthony Kennedy, who interpreted the 14th Amendment saying that same-sex couples have been denied equal treatment under the law. And the argument in that case, from that standpoint, was understandable, because you had many communities that had a law that if somebody was sick and they were in a hospital, only a family member or a spouse or something like that could come visit them. Well, gay couples were being denied that, and insurance and other things that were going on at the time. There was a debate going on in the country at that time. Do we want to go the direction of gay marriage? Because gay marriage is going to be, you know, how do we feel about children being raised in that marriage? Well, why should it make any difference? Well, of course it makes a difference. You know, these discussions go on. This is how we as Americans do things. We have debates, we have discussions, then we have elections, and then we have legislative people who make those decisions. But this decision stopped this discussion, and it's over. Some people say, well, maybe we can. No, that discussion is over, but it is something where they're going to have to discuss what does that mean, and what kind of permissions do we want. Each state has its own way of looking at that. So Justice Kennedy's famous quote that he said when releasing the decision was, "No longer may this liberty be denied." So states had challenged on the basis of federalism that marriages were something that was decided by the states. When I used to teach government class back in high school, I used to talk to them about that there were certain aspects of states where you had to recognize the laws of the other states. It's in the fourth Article 4 of the Constitution. So, for instance, I start off with the kids. I said, how many of you have a driver's license? And, you know, a couple of them raise their hands. I said, okay, how many of you have a United States driver's license? No. All right. Does it say United States of America? No. Mine says Missouri. Mine says Kentucky. Mine says state. Right. We decided that those decisions are made by the states, part of federalism. So is the decision about things like, you know, what are the rules about election? In some states, they have early voting 5 weeks before election day. In Missouri, we don't. We have 1 day. And I'm not saying which one's right and which one's wrong. I kind of prefer Missouri's way, because right into the last minute, I have everything I need to think about, and then I go on election day and vote and make that decision. But that's for the states to decide. Now, people are talking about, let's make that a federal thing. I hope they don't, because I don't think that's federal government should be involved in. And it may even be charged. Yeah, I would challenge that constitutionally. And depending on the makeup of the court, you may or may not win that. Anyway, again, Federalism is one of the things I want the kids to understand when they come into my class and learn about the United States of America. We have that system for a reason. We have that system because you had people who founded this country who distrusted centralized power. We fought a revolution to be free of a king and a parliament, not just a king, but the parliament. We didn't elect any of the parliament. No taxation without representation. Same thing here in the United States. We want to have more of the, we don't want the federal government saying, if you don't do this the way we want you to do it, we're not going to give you federal education money. Well, maybe we shouldn't have taken that federal education money. But as a local group, now we're going to decide, here's what's going to be taught in our schools. Now, we're seeing the first challenge to that, right? We all know what's going on in Florida, right? Ron DeSantis versus Disney, Disney doesn't like the law that's being passed by, and they always say, Ron DeSantis, wait a minute. Ron DeSantis is not the dictator of Florida. Ron DeSantis has an elected legislature. They passed a law. He signed it. He agreed with it. So, well, that's because they're all the same, a lot of them in the same party. Yes. And how did they get there? They were elected. People elected representatives say, you represent my viewpoint on this. I want you to go do this. And so when you start coming in conflict with a centralized power, Americans kind of automatically react to that. So keeping the power closer to the people and having federalism is important, much more than whether or not something like this decision is made one way or another. Having those choices closer to home is really important. Okay. Now the one I said that we would talk about, it's the NFIB. I forget what it stands for. National Federation of it's a interest group that has to do with businesses versus Sebelius, who at that time was the Health and Human Welfare, I think, secretary under President Obama. And we all know it as the Obamacare decision. Okay, and it was passed through both houses, signed by the President of the United States. And the question came down to to the people who were suing on it, a very simple decision. Does the government have the right to force you to buy something? Okay. Well, they force you to buy insurance on your car. No, they don't if you don't own a car. Well, I had people, I used to be a broker down in South Florida. I had people who had a lot, driver's license and hadn't driven in 40 years because they'd taken mass transit. That's fine. That's great. But you're required to have insurance by a state law. They say you have to have insurance and it has to be this much. It has to cover these things. Okay. That means your representatives that you voted for in your state have made that law. Can the federal government require you to buy some? Now, a majority of people felt that something that had been used throughout history in the Constitution called the Commerce Clause did not allow people to be coerced in that way, that you have to pay into this, you have to have this health insurance and get it through the government. The Chief Justice initially was going to go with the people who said this is unconstitutional, but then believed, and this is from his own conversations with people, that it would cause such a pressure on the court and cause the people of the country who had voted for this Congress and the president who would pass this through, that it would destroy the reputation of the Supreme Court with the voting public. And so in the end, he found a way to vote for it by considering the mandate provision of Obamacare, which says that you must pay this minimum amount in order to get the health insurance you're getting through. In other words, it was under Congress's power to tax, one of its enumerated powers in Article 1, that John Roberts changed his vote in favor of it, and that's how Obamacare got through. And the discussions between Chief Roberts and a lot of other members of the courts have continued ever since that time, but it was a very big decision when that happened. Now, my recollection is that President Trump ended up saying, yeah, but you can enforce it through your taxes on your 1040 when you file your taxes. And once that mandate went by for having to pay for it, a lot of it stopped. And so they're not really covering it with the mandate that you're supposed to pay into it, because right now people aren't being required to pay into it. I think they haven't tried to reverse that because they haven't got enough votes in Congress to reverse that part of the repeal of the mandate. It will be interesting to see where that goes going forward. So what are people learning in law school today? And the recent Judiciary Committee questioning has been for a guy who's taught government class for the last 20 years, shall we say, hair raising. This is, by the way, it's just a picture of President Biden and Justice Ketanji Brown Jackson as they're watching the vote on her confirmation to join the Supreme Court. One of the questions that was asked by Senator Kennedy on the Judiciary Committee of one of the nominees coming forward to be a federal judge is, what is purposivism? And what purposivism is judging to enforce the spirit of a law, even if it contradicts the letter. In other words, yeah, maybe the letter of law says this should happen, but I really want to make sure this happens. So we'll find a way to make it do that, when what judges are supposed to be doing is interpreting the law as it's written. And once you know how you want the story to end, the idea is you find a way to get there. Now, law school is not teaching as much law as they used to, so much as they are teaching activism. We want you to go out there, we want you to get on corporate boards, and we want you to have you follow these ESG rulings. I'm assuming everybody knows what I'm talking about when I say ESG. This is all these scoring that's done to say, you know, you're environmentally sound, you're following certain guidelines. And we just give it the term woke these days. And so a lot of that's going on in law school. And it's a moving target that leaves the public confused because they have no idea what direction the law is going in. Now, this is Senator Kennedy up here in the top left part, and he had a panel of 4 nominees. Actually, those 4 nominees are the only 4 nominees that have been nominated by President Biden that have not yet got a vote on the Senate floor, because the judiciary has not voted out their nominations in agreement. That's why, if you've been hearing about the brouhaha about Senator Feinstein and whether she should still be a senator, the problem they have is that she's the chairman of the Judiciary Committee, and she's not well enough to be at the Senate right now. So she's back home in California. Without their vote, they can't pass these 4 people that they want to get through. All the other nominees, I think 24, 25 have gotten through at least some Republican votes. So they've gotten approved. It's these 4 that haven't. And here's why that hasn't happened. So, you know, you can find this on YouTube if you want to. I'm not going to play it here. You've got to be able to understand simple legal ideas, or even the articles of the Constitution. And one of them was asked, what is Article 5 of the US Constitution? And the response is, well, that's not quite coming to me right now, Senator. It's not coming to mind at the moment. And I'm thinking, Article 5? I teach it in high school. I know an article. Article 5, by the way, is the article about the amendments. And then the next question was, well, how about Article 2? And that wasn't coming to mind at the moment either. This is a person who had been asked to be approved to be a lifetime appointee to the federal bench and didn't know what Article 5 or Article 2 was. Article 2 has to do with the presidency. And so that's a problem when you have people who are being appointed, not because of their knowledge of their law and their wisdom to be able to judge it, but because we know that they'll vote certain ways on certain issues. And that's a challenge to the Constitution, and a challenge to the way that our country is supposed to be run. And then we have the problem that we are going to have to figure out at some point in time, what about when liberties conflict with power? And the idea is that civil rights are supposed to be for everyone. We certainly saw a civil rights movement to establish that, unless the government sees a conflict. And I think you're going to see a number of suits relating to the way either the federal government or certain state entities went about enforcing certain guidelines during COVID. And the main reason for that is what we call the, this is for thee, but not for me. People would say everyone has to be at home, and I'm going to go out and have a restaurant with my friends unmasked or something like that. So I think you're going to see a lot of those coming up. Some of you may have heard about the church in California just lost a judgment in a federal court for $1.5 million, I think, for having church services during the COVID restrictions in California. Do you have the right to not take the vaccine? Some states didn't have that requirement. Some states did. I know in my son's case, he went down to the last day where his business, who had hired him for almost 20 years, was going to fire him because he would not take the jab. And I think you're going to have some cases on this. It's going to be very interesting to see what they decide. So personal rights versus state protection is going to be an area that the court is going to have to make some decisions. So what is next? What is the future of the court? And this is where the interview of Ketanji Brown Jackson, again, I'm not picking on her. It's just an example of the kind of waters we're wading into right now. And I'm sure most of you know what I'm going to talk about here, where she was asked by Marsha Blackburn of Tennessee, what is a woman? And Ketanji Brown Jackson, I think, saw that this is going to be, what am I going to do? Solomon's going to have to divide the baby in half. And so her response was, I can't say, I'm not a biologist. And the reason that's going to be a problem is in the future, this is definitely going to be one of the areas the Supreme Court is going to be asked to decide what are certain biological things that can or can't happen. What are certain requirements the government can make? What are certain things that will be allowed in the name of finding, new drugs or new procedures or new vaccines or whatever it be, and whether they're allowed to do that under the Supreme Court's interpretation of the Constitution. So this is why I feel so strongly that the public needs civic education, because in the end, as my favorite president says, this is a government of the people, by the people, and for the people. And if we lose sight of that, regardless of what the Constitution's language is, then we've lost our way and we've lost the country that was founded for us. So asking ourselves how the Constitution affects and protects our lives is really important. And here I get to put in my plug, is why you should support the education we're doing here at Cal. And that is the end of my presentation. I'm happy to take any questions at this time. I should probably look and see if we have, oh, I see Q&A here. What do I do in that? Should I look at that? Beth, are you around? If she can do that, can you pull that? Because I may not want to show those questions to the whole audience here. Maybe I'll do this. How about if I do that? and if anybody has a question here, just shoot your hand up and that I can handle right away.
Oh,
yeah.
Yeah.
Oh, okay. Yeah. Okay. I'll get to these questions in a second. Let's try it with somebody here. Go ahead, Mr. Shutt.
When the draft was leaked, I mean, it was just, the thought was, we'll find out who it is because it's going to be really simple. We still don't know.
Well, I think more than that, I'll give you an example. What if they leaked the Obamacare decision before Justice Roberts changed his view and decided to join what eventually became the majority, which is absolutely not only his right to do, I would hope he would do. I may or may not agree with the decision, but don't do something to pollute the process. It's worked, for 230 years. Has it had problems where it's failed? Sure. You want to know why? There are humans involved. We make mistakes. But to do something like that is so disdainful of something that has served us really well for so long. And the second part of that really disturbs me is we've heard nothing on that. And I get the sense we're not going to. Maybe someday when somebody dies, we'll know who was in the 6th floor of the book depository and we'll find out who leaked the decision. I don't know. But the fact of the matter is that
Do you think they know? They just don't want to...
Just so you know, those of you who are online, the question is about the leaked decision. I'm sure somebody has a pretty good idea. How do I do this? There are 3 things that I think are really important in this country going forward. And one of the reasons why I'm doing what I'm doing, and God bless Cal for letting me continue to do it. One of them is a really good civics education. It's such a disservice to our children to not give them a good civics education. Part of that is just education in general. We're having fights go on about that. People like Ron DeSantis have been attacked because of what they called the Don't Say Gay bill. I thought he handled it really well. It says, show me where it says that in the bill. And reporters should do their job, and they're not. Part of that's because they don't know what their job is. Journalism school is not about, who, what, why, when, and where. It's about, you're going to change the world. You're going to make things better. You're gonna do things that affect, and that's not your job. That's the people, the voters, and through their elected representatives' job. Your job is to give an educated, balanced view of the issues so that the voters can make a decision. And that's why that is the only industry that has constitutional protection in this country, is the press. And they're abusing it. And we need to, there's different ways to do that. Pressure them, write about it, and I tell people this just about every talk I give. Say something. When somebody says something that you think to yourself, well, that's not right, but I don't want to get into a big fight. This is my friend. Yeah, but by your silence, you're saying you agree. And at some point in time, you have to find a way, maybe nicely at first, and maybe you can't be nice about it eventually. But you have to, if you don't defend it, we're going to lose it. Who is it? Winston Churchill says every generation has this chance to lose freedom. And we've got to stand up. And that's why, as long as Cal will have me, as long as I can do it, my kids will get, I'm much more vociferous in my opinions with you all than I am in my classroom. I'm happiest when I have a parent that says, I don't know, what his views are. So good, you shouldn't, because that would be an abuse of my position as a teacher. But I do want them to know what the laws are. I do want them to know what the rules are. I do want them to know what their government setup is. That's very important. So that's kind of my answer there. Yeah, go ahead. And I do have these other questions. I want you guys to know online. I do see your questions. Go ahead.
Yeah, I was curious how they came about that they made the Supreme Court judges no term limits and no age limits. But there are some states that have state judges that have limits on them. And is that ever going to come up?
Well, I think, okay, here's another thing. The question is about some places have limits, some places do not. Obviously, with the federal judges, they do not. I think, first of all, number one, they never expected, we'd have judges still in the Supreme, presidents and judges still in serving in their 80s and things like that. And a lot of them that have gone that far have stepped down, and good for them. But I think there's a way to change that if you want to change that. It's called an amendment to the Constitution. For the last 40, 50 years, some people have been trying to change the Constitution, not by amendment, but by the way they want to interpret it. And that's wrong, because that cuts the public out. Let the voters vote. I'm in favor, and I'll say it right here, and I'll take whatever heat anybody wants, because I'm a favor of a convention of the states. It's part of nobody ever talks about it. There's only one time we've ever used it, and that was to eliminate prohibition. Okay, the amendment that eliminated prohibition came through. That was really easy. All the state, it didn't take long for the state to say, yes, get rid of it. We want to drink. But we need a convention of the states. And, that's the only way you're going to get a balanced budget amendment. That's the only way you're going to get term limits on congressmen. Why? Because the only other way to do it says my battery is running low. So the only way that's going to happen is because the way that we've used 26 out of the 27 times, that's not true. 16 out of the 17 times after the Bill of Rights was Congress has to pass any amendment by 2/3, and then 3/4 of the states have to approve it. Hard to do. It's really hard to do, but it should be, because you're changing the basic rule book for all 50 states. So it should be something that a large super majority, not only of the Congress, but of the states agree. This is a good idea. We should change it. Women should have the vote. We should have income tax. Okay, that one they got wrong. But I mean, that's the way those things happen. Now, people say, well, if a convention of the states, I'm going to get all these crazy amendments. Who cares? They still have to get 3/4 of the states to approve it. And why do they not know that? Because our press isn't telling us, because they're afraid of what will get passed. Does anyone know the last amendment to the Constitution we've had? It's the 27th Amendment. Okay, good. I get to tell you the story, because it's a real short story, but it's a great one. It was one of the original 12. When they came out of the ratification process, James Madison pulled all the suggestions together and came up with 12 amendments. The first 10 are what we call the Bill of Rights. Okay, we're all familiar with most parts of the Bill of Rights. The 11th was going to be to change the way that certain things were done in enforcement, and they decided we'll do this through laws. It's a better way to do it. They did. That's fine. The 12th Amendment became the 27th Amendment over 200 years after it had been first approved by Congress. And you're going to love it. It was the one that said any increase in the pays of the congressman and senator does not happen until after the next election. In other words, you have to rehire them before they get a raise. That makes complete sense, doesn't it? But it took 200 years to do that. And a law student in the University of Texas that was writing a paper saying, oh, I wonder what happened to that other amendment, you know, because if you went to law school, you knew there were 12 originally and 10 were approved in one of the Bill of Rights. So he looked it up, called the archivist in Washington, D.C. and said, is this still open for ratification? And most amendments have in it, like the ERA. Most of you are familiar with the ERA, right? The last part of the ERA says this amendment must be approved through the amendment process within 10 years after its passage by Congress. And it didn't. That's why it failed. They even gave a 3-year extension and they still failed. Okay. This one didn't have that. It could still be approved. And this is right after the house banking scandal. Remember this, guys, again, the post office scandal, you know, all these things that Congress had all these rules that didn't apply to anybody else, you know, but, you know, they could do whatever they want. And so when people found out that, geez, if we ratify this amendment, you know, they can't vote themselves this pay raise at 3 a.m. where we're not looking, we go, wait a minute, you're not doing your job. Why should you get a 30% pay raise? So now they have to get reelected before they get that pay raise. And that thing passed quickly. By the way, the poor guy got a C on that paper and was angry with his professor. And eventually the professor apologized later on. And then for a number of years, he was the advising legal authority for the Texas state legislature. They were so happy with him and say, you got a job. You know, but anyway, it's again, if we had a convention of the states, the things that you would expect to see go through there would be things like term limits for Congress, a balanced budget amendment. Now, maybe they won't pass, but that'll be up to us through our state legislatures who we've elected, as opposed to congressmen and senators who are going, no way, I want to have to do a balanced budget. Man, I get elected every year by voting for more spending than money that we've taken in. Or, you know, I don't want that to happen. I want to be able to serve here for 30, 40, 50 years. No. Maybe you should have it. And if you have a term limit, you're not going to have people who are going to want to go in there and make tons of money by being in Congress forever. They're not going to be able to. You know, maybe senators 2 terms is enough. Maybe congressmen 4 terms is enough. I don't know. Let's see what happens. Let's have a. I'm sorry. Say again.
What about the justices?
Yeah, well, and that's another thing. Maybe people will say, hey, 20 years as justice is enough, or 20 years as federal. Right. And that's possible. That's possible. But again, that will have to be ratified by 38 states. And if that's happened, then that means a majority of the people's elected representatives on the level that most people are familiar with, they know who their state senator is or the state assembly, have decided this is a good idea. And this is something that will benefit the country. And the reason it didn't happen before is because nobody thought anybody would want to serve that long. Benjamin Franklin wanted them to be unpaid, and they said, no, if that happens, nobody will want to be in Congress. So they decided they would pay them from the public treasury, but nobody expected people to be in Congress for 20, 30, 40 years. This is recent. And again, I attribute a lot of that to the power that was amassed by having this huge federal bureaucracy that grew up under the New Deal and under the Great Depression. That's become a private, unanswerable part of the federal government that even the president of the United States can't do anything about. And that's got to change. That's got to change. Okay. Any other questions before I go here to online? Let's see. Okay. Hi, Keith. Mr. McKinney. And I'm not going to name the people. Anyway, no question. I just want to say hi. Okay, thanks. Other people are saying we weren't able to come because of the thunderstorms. Okay, well, I guess, okay. Any other questions here? Or have I've held you too long? Well, I'm so grateful. Look, I want to end it this way, and I'm going to find ways to be better at this too. Hopefully, unfortunately, I got my wife who's always by me, who's trying to keep me calm down and stuff when I get worked up. But we do have to start speaking up. We do have to start saying something because we care about our country, and we care about keeping the country as it was founded, because it was founded in a way that gave opportunity. I tell this. Okay, here's one thing I tell my kids. I said, I hope you appreciate where you are, where you live, your parents, your family, your school, your community. Because right now, as we're speaking, people are dying literally to get here. So let's keep the good country that we have set up here. So we'll continue to be someplace that people will kind of want to come and be a part of, and let's protect it. Because I guarantee you, your younger generation coming out of schools do not know anything about this country or its founding, or the framing of the Constitution, and what's special about it. They hear about things that are good. They want to look at TikTok videos, you know, and that's fine. They should have the freedom to do that, but they need to be educated, and they aren't. And that's why Mrs. McKinney set up CAL, and I hope you will support it. Thank you for your attention and have a good evening.